My name is Bartow, and I'm going to spend about 20 minutes talking to you about the intersection of copyright law and access to state law. Under the U.S. copyright, federal statutes and federal case law are not copyrightable. Section 105 of the U.S. Copyright Act states, copyright protection under this title is not available for any work of the United States government. So laws like the Copyright Act or any other federal statute is not subject to copyright. And then federal case law, which is what we call judicial opinions that are issued by federal courts, are not copyrightable either. The United States federal government made this choice because they believed that the citizens ought to have access to the laws that bind them, that they ought to be able to read the statutes freely, and that they ought to be able to look at court opinions freely, completely in an unfettered way, because copyright is a mechanism of control, and they worried that if the federal government could control access to laws or access to court opinions, that could be trouble, right? That people needed to have some transparency and to have faith in their government and to have faith in the judicial branch. However, that only applies to the federal government. Because we have a federalist system, a lot of options are left available to the states to run their states the way they want to. So Section 105 only applies directly to the federal government, and state governments are free to handle copyright of their laws any way they like. Many states rely on private publishing companies to publish and distribute both their state codes and state judicial opinions, which is, again, we call case law. We call it case law because it can often function as law in and of itself. The statutes are what the legislatures decide the law should be, but when the courts interpret them, they sometimes explain how the law should be applied in different factual situations, and that also has the force of law. It's called precedent, and it's also part of the body of law that governs people. So states, instead of publishing them themselves, at least some of them, will allow private publishing companies to publish them, and that means, and they're available then for a cost, a fee, if people want to obtain copies. Sometimes these private publishing companies want to be the exclusive publisher, and so they'll actually contribute money to state coffers because they in turn profit from this. So this means that the publications of the state statutes and the court opinions generate revenue streams for both the private publishing company and the states that do this as well. These revenue streams are enhanced if there's no free source of law available that can compete with the for-profit versions. So there's kind of a bad incentive to go ahead and do this because the publishing companies are happy, they make money, and then there's a certain bent in some branches of government by some government officials that you shouldn't spend taxpayer money if you don't have to. So if this allows them to have not only free publishing, basically free to the state, not free to people who want to see the law, but it gives them a revenue stream, so they're even more incentivized to keep this in place. So this creates a temptation to assert copyright protections over the official versions of state statutes and case law reporters to keep an exclusive contract with publishing companies. This, back in the 1880s, was viewed as a bad idea, at least by some states. There was a Massachusetts case in 1886 in which the judge wrote that every citizen is presumed to know the law, and therefore justice requires that everyone should have free access to opinions, and that it's against sound public policy to prevent free access to the law or to suppress it or keep from the earliest knowledge of the public the statutes. So they made a strong statement in favor of public policy being in favor, completely in favor, of individuals having unfettered access to the law, meaning in modern times multiple publishing companies could pick up the statutes because there's no copyright and publish them. So you'd have more competition, you'd have lower prices among the private publishing companies, and some progressive states in that way might also publish them themselves to make sure that they were free and freely available. So the public policy is you're presumed to know the law, it's the government's responsibility to make sure you can find out what that law is. Asserting copyright-based monopoly power over state law is just generally bad public policy. First, we have the statement that ignorance of the law is no excuse. You probably heard that before, and that is if you violate a law and you say, but I didn't know that was the law, no one is going to say, that's okay then. They're going to say, well, you're supposed to know the law, you're supposed to educate yourself about the law, and you're supposed to follow the law. And if you broke the law, we don't care whether you knew or not, because it's really your job to know. So it doesn't get you off. An example I like to give my students is toll roads, right? If you go to here, we're near the Massachusetts Turnpike. There are toll roads in New Hampshire. Probably every state has toll roads. So we pay to use those roads, even though taxpayer money funded part of the roads. And the idea here is that the people who actually use the road should, pay more than just sort of the average taxpayer. So that's why we pay tolls for when we're on the road. But what if, in addition to charging us to use the road, the toll road people said, okay, want to know the speed limits? Well, you're going to have to pay us extra money if you want to know what the speed limit is. I don't think we like that very much or think it was very fair. We like to have speed limits posted so that, we don't say ignorance of the law. We say, okay, 50 miles an hour, and then am I going too fast, too slow? Am I in danger of, breaking the law? So we wouldn't really like that, and yet when states keep law is something you have to buy to have access to or pay to have access to, essentially they're kind of hiding the speed limits and asking you to pay more if you want to see what they are. I think that passing and enforcing laws are core government functions, and informing the citizenry what these laws are is also a core government function. I don't think saving taxpayer dollars is helpful in the long run if the tax-paying citizens have to pay special fees to find out what the laws say and mean. And sometimes states say, well, these for-profit journals put copies in public libraries, so you could actually go and maybe check out the statutes or at least sit in the library and read them, so that solves that problem. But I don't think citizens should have to go to a public library to gain free access to state laws. It's a workaround, it's true, but it's one that's not very convenient. In the age of the internet is a terrific technology that can bring state laws and all kinds of legal information to the public at a very low cost. Some states very proudly post their laws and their court opinions on the internet because they want the residents of their state to have access to the law. I think that's a really great idea. In 2002, there was a federal case that addressed this in the Fifth Circuit, Veeck versus Southern Building Codes Congress. It was eventually an en banc session, which means everybody in the Fifth Circuit, all the judges heard this instead of one judge or a small panel, because it was viewed as important, so everybody got a chance to weigh in. The issue in the en banc case was the extent to which a private organization, SBCCI, could assert copyright protection for its model codes after the model codes had been adopted by a legislative body and become the law. Specifically, the question presented, as articulated by the Fifth Circuit, was, may a code-writing organization prevent a website operator from posting the text of a model code where the code is identified simply as the building code of a city that enacted the model code as law? So they addressed this question, and the facts are Peter Veeck got a copy of the 1994 model building codes from Southern Building Code Congress International. So this is a nonprofit organization that came up with building codes. They had people that belonged that knew a lot about building codes. And then various municipalities would sometimes adopt those model codes into law. Sometimes directly the whole model code, sometimes only parts, and sometimes they would modify it for their, for what was ever going on in their jurisdiction. For example, you could understand that some areas with rocky soil might have slightly different building codes than a place with sandy soil. So they would modify the model codes, but essentially they would adopt some of this. SBCCI let the state governments and the local governments use their model code for free. They made their money by forcing people like contractors or people who wanted to do renovations pay for the code. That was their business model. So it's $72 if you wanted to get a copy. Well, Peter Veeck didn't think that was very fair, so he bought a copy for $72 and then he put it up on his website. Well, SBCCI didn't like that at all because this gave people a workaround, free internet-based access to their code that they had spent some time and money in preparing, so they sued for copyright infringement. En banc, the majority of the Fifth Circuit judges thought that allowing copyright in the model code was okay as such. In other words, when it was just a model code written by SBCCI, that they could have copyright in it. But the majority believe that once the model codes were enacted into law, either directly or as modified, that they could no longer be copyrighted. That once a model code was enacted into the part of the code that was enacted into law, entered the public domain, and everyone should have access to it. So that was the majority ruling, very much in favor of public access. The dissenters, however, had two primary objections, right? The dissenters were the minority of the people, the judges who wanted to vote against Veeck. First, when Veeck bought the code, he had agreed to terms and conditions, and they said he's violating them when he put it on his website. So for that reason, he's a copyright infringer. And another judge, and a couple judges went along with him, thought that technical codes and standards are very necessary, and we need private organizations to develop them, and that if we don't allow them to retain copyright in their model code and profit, or at least collect money for what they did, that they'd stop writing them, and that would be a problem. The loss of those organizations that did the code would be a big problem, and so those judges thought stripping the copyright protection was a bad idea. So that was 2002. In 2008, the state of Oregon began asserting copyright in the Oregon Revised Statutes. And Oregon's Office of Legislative Counsel sent cease and desist letters, which is stop doing that letters, to websites that were hosting the Oregon Revised Statutes that said in pertinent part, we don't really claim copyright in our laws itself, but we have arrangement and subject matter compilation, explanatory notes, prefaces, headlines, numbering, etc. And all that's copyrightable expression, and it's copyrighted, and we're asserting our copyright. We'd like you to take the statutes down. Well, two law professors who are kind of heroes of mine, the late L. Ray Patterson, who was at Georgia, and Craig Joyce, who's at Houston, and some other advocates, persuaded Oregon to change its mind. They said there are many things that copyright is good for: education, entertainment, even participation in the political process through journalism. All of them are governed by copyright, and for the most part that's a good thing because copyright law incentivized creation of these things. But they said once you look at law itself, the effect becomes negative because it gives precedence to private proprietary rights, the private publishers, over the civil rights of the citizens to have access to their law. After taking testimony on the matter, Oregon's Legislative Council Committee unanimously voted not to enforce any copyright claims on the Oregon Revised Statutes. That brings us to contemporary times. Now, if you want to read the official laws of the state of Georgia, it will cost you more than $1,000 payable to a private corporation. Another activist, Carl Malamud, bought a hard copy of the official code of Georgia annotated. So this is the laws, and then the annotations are explanatory keys that tell you what the laws mean or how Georgia courts have interpreted the laws. It cost him $1,207.02 after shipping and taxes. He could have gotten a CD. He got the hard copy. That would have cost even more. There was a version up for free on the state's website, but it was unannotated, so it didn't have any of the explanatory text telling you what the laws meant or what Georgia courts had said the laws mean. So it was incomplete and not something you could really rely on. Malamud believes that access to the law is a fundamental access of our system of democracy, an essential element of due process, equal protection, and access to justice. And I agree with him. In his advocacy, he posted a copy of the laws to his website, publicresources.org. He was soon told to stop copying, destroy his files, and move the laws from his website, and if he didn't comply with 10 days, Georgia would file a lawsuit to force his hand, and not only that, was going to sue him for damages and for willful infringement. Malamud did not take his statutes down, and so they sued him for copyright infringement, and in their complaint, they accused him of piracy, and that said by putting the laws up on his website, he was engaging in a form of terrorism. Malamud got sued. Malamud lost at the district court level. A U.S. District Judge, Richard Story, sided with Georgia. The judge disagreed with Malamud's argument that the OCGA, the official code of Georgia annotated, couldn't be copyrighted, and also said that Malamud's copying of the laws was not fair use, which is an exemption from copyright that allows you to use copyrighted works without the authorization of the copyright holder, usually because you have a good reason or a public interest reason, which one might argue, and I would certainly argue, Malamud does here. The judge said the Copyright Act specifically lists annotations in the works entitled to copyright protection and said defendant admits annotations in unofficial code would be copyrightable. Malamud didn't really argue it wasn't copyrightable. What he's arguing is copyrighting it is a really bad idea and enforcing it, the copyright, is a really bad idea and very contrary to public policy. Despite the fact that the OCGA is the official law under Georgia laws, the judge said the annotations were entitled to copyright because the Georgia General Assembly had made clear that it contains both law and commentary, and Stories thought the two were distinguishable. In the fair use analysis, publicresource.org and Malamud were treated very harshly. Story made the rather extraordinary finding that they were engaging in commercial copying, even though it's a nonprofit website that made the law available for free. The judge's argument saying that the organization profits by the attention, recognition, and contribution it receives in association with its copying, distributing the OGCA annotations, and that took it out of the realm of nonprofit and educational uses, which are typically, not always, but typically fair uses. The judge also found the annotations were original works entitled to broad copyright protection and blasted publicresource.org for having misappropriated every single work of every annotation using a bulk industrial electronic scanner. Carl Malamud is appealing this verdict. Malamud says the official code of Georgia annotated is an edict of government and contains the definitive statement of the law as published by the state of Georgia. Every bill that's passed by the Georgia legislature describes itself as an act to amend the official code of Georgia annotated, right? That pretty much proves that the annotated code is the official law, and goes on to say the official code of Georgia annotated, every component of it is the law. Carl Malamud says the publication of the official code of Georgia should be encouraged, not threatened. And again, I tend to think he's correct. Georgia lawmakers, however, maintain that Malamud's argument is overblown because the unannotated, the law, the statutes without the explanatory text, is freely available. But Malamud's pointed out that that's not even free in the sense that it's incomplete and it's not unfettered, because you have, even if you want to see the incomplete, unannotated version, you have to agree to onerous restrictions and 2 separate terms of use. In other words, you have to enter into a contract with the website just to see the quote-unquote free statutes. You also have to agree not to make any copies, and you have to agree you can't make copies of the code and use it in newsletters or articles. You can look at it on the website, but you couldn't copy it or cut and paste parts of it for a legal publication, for example, that you might have that explain the law. For now, due to an injunction, Carl Malamud had to remove from publicresource.org the Georgia laws, and he replaced it with a notification that said, your access to this document, which is a law of the United States of America, has been temporarily disabled while we fight for your right to read and speak the laws by which we choose to govern ourselves as a democratic society. Carl Malamud would very much like Georgia to follow the example of Oregon and other states which really thought that it's important and continue to think to make sure that citizens have access to their law. So I would offer you as a final slide my opinion on this matter, which I think I've already hinted at or maybe stated quite unsubtly, which is that Georgia should lose this lawsuit when it goes into the Federal Court of Appeals. That, as I've tried to explain, there are strong public policy reasons to make state laws available to the people who are bound by them. Now, Georgia says the distribution of the OGCA by Malamud negatively impacted LexisNexis' ability to make money off the sale of the annotated code, which costs $395 for Georgia residents and more than $1,200 for non-residents. That's why Malamud had to pay that much. $395 for Georgia residents, people who are already paying taxes to have a state government if they want access to the annotated code. Again, the difference between annotated and unannotated is explanatory text. Lawyers like to have explanatory text so they understand better what the statutes mean, because it's not always clear from the language in the statutes. People who are not lawyers especially need the explanatory text. They're not lawyers, and they need any information they can have to help them better understand the Georgia laws that bind them. So again, I think this is really against public policy. For whatever reason, Georgia's approach enriches private corporations like LexisNexis with no corresponding public benefit. I like LexisNexis, I use their service, and I'm not averse to them making money. But I don't think they should be making money off of people who simply want to have access to the laws of the state of Georgia. In my view, Malamud is fighting to make because Malamud is fighting to make the laws of Georgia accessible at no cost, he's a hero. He's not a terrorist.